I will give the floor to Dr. Marco Ricci. Marco Ricci is a researcher of Sapienza University of Rome, is a lawyer, and he has a PhD in public law. Please.
Good afternoon, everyone. I am Marco Ricci, and I thank Dr. Calderari for the invitation to this event, and I proceed to explain the topic assigned to me, that is the Italian legislation on waste. So, let's begin by, by defining the concept of waste according to the Italian law. The reference source of law is the legislative decree number 152 of April 3rd, 2006, also known as the Environment Code. Article 183, paragraph 1, letter A of such decree defines the waste as any substance or object which the holder disposes of or intends to dispose of or is obliged to dispose of. It is necessary to specify that in any case, the waste is exclusively a mobile material good. Immovable goods, such as, for example, contaminated land that has been taken from a place in order to carry out a remediation, are not waste. To understand the exact concept of waste, it is also useful to distinguish the latter from two other concepts, namely that of product and that of byproduct. In this regard, in addition to the normative data, it is necessary to recall the indications provided by the jurisprudence of the Court of Justice of the European Union, whose guidelines are fully transposed into the laws of the member states of the European Union. As regards the difference between the concept of product and that of waste, we can recall what the Court of Justice of the European Union said in judgment of April 18, 2002, in case C9/00, also known as Palingranit case. The court, in particular, stated that the difference between the product and the waste lies in the absence of prior processing operations and in the certainty of reuse without harming the environment. With regard to the difference between the notion of waste and that of byproduct, first of all, it should be remembered what is established by Article 184 bis, paragraph 1 of the Environment Code, according to which it is a byproduct and not a waste, any substance or object resulting from a production process whose purpose is not to produce the substance or the object. The byproduct must be used in the same or in a subsequent production process, also directly, without being treated differently from what would happen in the normal industrial practice. The indications of the Italian Environment Code should be read in conjunction with the assertion of the Court of Justice of the European Union, which, in its judgment of December 22, 2008, case C283/07, stated that byproducts may only be configured in those situations in which reuse, including that for the needs of economic operators other than that one that produced them, so reuse is not only possible, but certain, proceeding from preliminary processing operations, and takes place during the production. In order to view the judgment of the Court of Justice of the European Union, you can use the link I indicated in the slide. So, in addition to a general concept of waste, the Italian legislation makes it possible to distinguish a number of specific types of waste. We can reconstruct a so-called waste taxonomy on the basis of two different criteria. Waste can be distinguished first by their origin. So we have municipal waste on the one hand and special waste on the other. Article 183, paragraph 1, letter B ter of Environment Code provides a list of municipal waste referring, for example, to the household waste, mixed and separately collected, to the waste of any nature or origin, lying on the roads and on the public areas, on public use roads and private areas, on sea and lake beaches and on the waterways banks, or to the waste from cemetery areas and from cemetery activities. The Environment Code does not provide a specific definition of special waste. However, we can say that the notion of special waste includes certain types of waste that the code identifies individually. This is the case, for example, of waste from construction, demolition, and excavation activities, which are identified by Article 183, paragraph 1, letter B quater, or again, of waste from agricultural, agro-industrial, forestry, and fishery activities, of which Article 183, paragraph 1, letter B sexius speaks about. The categories of municipal and special waste can both be divided into two subcategories due to the specific characteristics of the waste that falls under them. Using these criteria, both municipal and special waste can be distinguished into non-hazardous and hazardous. It is on the latter in particular that we must focus. In fact, the Environment Code at Article 183, paragraph 1, letter B bis, states that the non-hazardous waste are all of them that fall outside the hazardous waste category. According to Article 183, paragraph 1, letter B, waste is hazardous whenever it has one or more of the characteristics listed in Annex I to the Environment Code. That annex identifies as characteristics capable of rendering the waste as dangerous, for example, the explosiveness, the easy flammability, the irritability, the carcinogenicity, or the toxicity. It is important to highlight that with regard to the treatment of hazardous waste, a particular emphasis must be given to the precaution principle, which is enshrined in Article 191 of the Treaty on the Functioning of the European Union. With regard to the identification of hazardous waste, the precaution principle plays an important role, as the Court of Justice has stated in the judgment of March 28, 2019, rendered in the cases from C 487/17 to C 489/17. In fact, the court has asserted that where, after a complete risk assessment, the holder of a waste which can be classified either with codes corresponding to hazardous waste or with codes corresponding to non-hazardous waste, well, where the holder is in practice unable to determine the dangerous substances present or to assess the dangerous characteristics of such waste, the latter must be classified as hazardous. So, the next issue we need to address is that of waste management, starting from the allocation of legislative powers in this field. In Italian law, reference must be made to Article 117 of the Italian Constitution, which gives the central state the competence to legislate on the environment and on the ecosystem protection. This does not mean that regions that are the territory government bodies of immediately inferior level to the central state cannot adopt laws that have repercussions on the environment, and more specifically on waste. However, state legislation acts as a limit, impetus or in melius, for such regional laws. In this regard, it is useful to recall the assertion of the Italian Constitutional Court, according to which regions cannot dictate rules that, with regard to the environment, set both less restrictive and more restrictive rules in terms of environmental and ecosystem protection. This is due to the fact that only the state can make a balance valid for the whole state territory between all interests and matters that may interfere with the protection of the environment. Regions, in view of the result of this balancing operation, cannot adopt derogations from the rules established by the state. Let's examine now the allocation of administrative powers in the waste management field. As you can see in the slide, different levels of government of the Italian territory are involved, together with an independent administrative authority. The state, in the person of the Minister of Ecological Transition and of Energy Security, mainly exercise programming and coordination functions. One of the main competencies of the state government level consists of the adoption of the National Program for Waste Management. This is a strategic guidance tool for regions and for autonomous provinces in waste management planning. This program contains, for example, the national waste production data by type, quantity, and source, or a national plant survey by plant types and by region, and the general criteria for the identification of the interregional districts that allow the rationalization of plants from a locational, environmental, and economic point of view, as far as according to the proximity principle. Regions can exercise numerous functions in the field of waste management. We can mention, for example, the assessment of new collection system needs, or of existing waste plants closure and of additional waste infrastructure needs, that in accordance with self-sufficiency and proximity principles. Regions are also responsible for the approval of new waste management plans projects, for the authorization of existing installations modifications, and for the definition of identification criteria for unsuitable or suitable areas for the location by the provinces of waste disposal and recovery facilities. The waste management, as you can see, also involves two other levels of government, namely the provinces and the municipalities. Provinces exercise control functions through the exercise of inspection and investigation powers with the support of the regional agencies for environmental protection. Municipalities perform administrative functions of a strictly operational nature, as we will see deeper later. Finally, in order to complete the framework of administrative competencies in the field of waste, it is also important to remember that in addition to the territorial government bodies, an important role is played by an independent administrative authority, that is the Energy, Grid, and Environment Regulation Authority. This administration carries out regulatory and control activities in the fields of electricity, natural gas, water services, waste cycle, and district heat, and that in order to promote competition and efficiency in public utilities, as far as to protect the interests of users and consumers. The tasks performed by the authority regard in particular local structures monitoring and governance, municipal waste tariff regulation, service contracts, standard schemes preparation, and quality regulation. By exercising these functions, the authority is able to reconcile the economic and financial objectives of service operators with the general objectives of social justice, environmental protection, and efficient use of resources. So, let's address now in more detail the issue of waste management activities. In this regard, first of all, we must introduce some of the guiding principles in the matter. We must take as a reference the indications of Part 4 of Environment Code, which includes articles from 177 to 266, and is specifically dedicated to the waste management. The articles on which I would like to focus in particular are, as you can see, Articles 177, 178, and 179. Article 177 defines the scope of Part 4 of the Environment Code, which is that of waste management and remediation of polluted sites. Article 177 identifies in particular the objective of the rules contained in Part 4 of the Environment Code, which is the protection of the environment and of the human health, avoiding or reducing waste production and negative impacts of waste production, and also reducing the impact of resources use and improving effectiveness and efficiency. Article 177 also states, as you can see, that waste management is a public interest activity. The general principles in the matter of waste management are defined by Article 178 of Environment Code. To the principles I have pointed out in the slide as an example, we must also add those of efficiency and of technical and economic feasibility. A particular importance must be given to the polluter pays principle, which is generally stated in the Treaty on the Functioning of the European Union in Article 191, paragraph 2, while its detailed discipline is contained in two European directives. First of all, we must recall the Directive EU number 35 of 2004, as modified by Regulation EU number 1010 of 2019, on environmental liability for the prevention and remediation of environmental damage. The directive establishes a framework for preventing and remedying environmental damage, and it wants to ensure that the operator who causes an environmental damage or an imminent threat of such damage bears the cost of the necessary preventive or remedial measures. With specific regard to the waste matter, the reference discipline is contained into the Directive EU number 98 of 2008, as modified by Regulation EU number 851 of 2018. This directive establishes a legal framework for the treatment of waste in the European Union, and the directive wants to ensure that the costs of waste management, including those for the necessary infrastructure and its operation, are borne by the initial producer or by the current or previous holders of waste. Finally, Article 179 of the Environment Code set the criteria of priorities hierarchy in waste management. That is, what measures encourage the options that guarantee the best overall result, taking into account the impact on health as far as including technical feasibility and economic viability. As you can see, The hierarchy places at the top the option of the prevention, and this reflects very clearly that the goal is to encourage the creation of a socio-economic context that, at the European level, should be increasingly inspired by the principle of the circular economy and less by the use of the option of landfill. On the basis of these principles that we have just paid attention to, we can now describe how it is organized and carried out according to the Italian legislation, the waste management service. First, we have to determine who is called to perform the service, and a distinction must be made between municipal and special waste. For the management of special waste, the market dimension prevails, and that in the sense that the producers of such waste use the services offered by private parties with which a special service contracts are concluded. Waste management is, however, still a public interest activity, so the operators to which the privates address must both satisfy the requirements and fulfill the obligations set up by the Environment Code. In the case of municipal waste, management is left to the municipalities in 98% of cases. So we can say that the public dimension of the service prevails. As I said before, I want to focus in particular on the urban waste management service, which can be carried out in three ways. There is, first, the possibility of outsourcing the service to third parties through a public evidence procedure, and to select the operator, the public administration applies the Italian public procurement discipline that is contained in the legislative decree number 50 of 2016. Secondly, the waste management service can be indirectly carried out by the public administration through an in-house company, that is, a private law company wholly owned by the administration and controlled by the administration itself. The third possibility, as you can see in the slide, consists in the use of a public-private company, participated by a public partner and a private one, and where the selection of this last one has to take place through a so-called double object competition that is finalized both to finding the private partner and to awarding the contract. Faced with these three possibilities, we mark that, considered on municipal base, competition represents the prevailing management award mode, followed the in-house awarding to public-private company, and then the insourcing management. So I pointed out that the waste management service is based on a number of principles, such as that of efficiency. Well, in order to ensure compliance with these principles, for the performance of the waste management service, the Italian territory is divided into a series of so-called optimal territorial areas, within which the service has to be performed. What is an optimal territorial area? This is a portion of territory that the Environment Code at the Article 202 requires to identify on the basis of physical, demographic, and technical criteria, as well as the presence of road and rail infrastructure that can optimize the waste transport, or of waste management plants already built and operated. The ultimate objective is to ensure that more territorial government bodies can carry out in an integrated way the public services, including that of waste disposal, and that by achieving genuine economies of scale and thus maximizing the efficiency of the service. Generally, the optimal territorial areas have a provincial dimension, but they can be identified on a regional, supraprovincial, subprovincial base, and that taking into account the territorial and socioeconomic differentiations, and in any case, referring to the principle of proportionality, of adequacy, and of efficiency in relation to the characteristics of the service. With specific reference to the waste management, the identification of an optimal territorial area can serve to enable or the entire service cycle to be carried out or to entrust individual segments of this. For example, singularly, collection, transport, treatment, or disposal. We can refer in this regard to articles from 199 to 206 of the Environment Code. Optimal territorial areas, according to Article 200 of Environment Code, are identified through regional plans as to overcome management fragmentation through an integrated waste management service. Each optimal territorial area is directed by an optimal territorial area government body, which is established by region and may have several shapes. For example, a non-economic public body or a municipalities consortia. So, one last profile that I want to examine before closing my speech concerns on legislation on waste disposal plans. There are two issues that I want to address in particular. First, what are the conditions for the construction of a disposal plant? In this regard, we must consider that the construction of a waste disposal plant is subject to the administrative procedure that leads to granting of an integrated environmental authorization. The latter represents a provision by which can be authorized the operation of specific types of plants, such as those used for energy, for production and processing of metals, and obviously for waste disposal. The integrated authorization is granted after the verification of the compliance with the conditions which ensure the pollution prevention and control, and also the compliance must be ensured with the environmental performances provided for by the best available techniques. With particular reference to the disposal and recovery of waste, Article 208 of the Environmental Code states that integrated authorization must be requested from the territorially government body, in particular region. The evaluation of the region is discretionary, may contain mandatory requirements, and more generally, it is issued taking into account the need to respect the principles set out by Article 178 of the Environment Code, about which we spoke just now. The procedure for obtaining the integrated authorization includes an application phase during which a project must be submitted. If required, the applicant must submit an integrated environmental impact assessment. We have a second phase of the procedure, that is that of the investigation, during which the competent administration can call a so-called conference of services. With the conference of services, rather than having to turn to several administrations in order to obtain the authorization of each of them to the project, all the competent administrations can express simultaneously their opinion in such a way as to arrive at the formulation of a common position to the region that will have to decide whether or not to grant the authorization. The final decision of the region must be taken within 30 days of receiving the evaluation of the Conference of Services, and in view of the fact that all the competent administrations have been consulted, the integrated environmental authorization replaces any other type of authorization given by a singular administration. As I said earlier, the integrated authorization contains all the conditions that must be met in order to build the disposal plant. And in the event of non-compliance with these requirements, taking into account the gravity of the infringement committed, the consequences may be those of the warning with the individuation of a deadline for the non-conformity removal. It is possible to have a warning with a warning with an authorization suspension for a fixed period, and that where dangerous situations for public health and environment occurs. In the most serious cases, for example, in the presence of failed compliance with the requirements imposed by the warning, or of a repeated infringement which endanger public health and environment, the authorization can be withdrawn. So, let's look briefly at the second issue in the matter of plant legislation. That is, what are the programmatic guidelines for overcoming as much as possible the landfill? As we have seen before, landfill, as established by Article 179 of the Italian Environment Code, is the last option provided by the hierarchy of priorities in the field of waste management. In this regard, some programmatic guidelines have been adopted in the European legislation, more specifically with the directives contained in the so-called Circular Economy European Package. This package includes a number of measures relating, for example, to the management of waste from packaging, from batteries and electrical equipment. The directive, which is specifically finalized to overcoming landfill as way of managing and disposing of waste, is the Directive EU number 850 of 2018, which, together with the others directive of the Circular Economy European Package, has been transposed by the Italian legislature. In fact, with the law of October the 4th, 2019, number 117, the Italian government has received the delegation to the adoption of some specific legislative decrees for the transposition of the European directives falling under the normative package on the circular economy. In particular, Directive EU number 850 of 2018 has been transposed by legislative decree of September the 3rd, 2020, number 121, which has made a number of changes to the previous legislation on landfill disposal referred to in the legislative decree of January 13, 2003, number 36. As you can see, over the next years, the European and the Italian legislator have set a series of objectives aimed at reducing more and more the practice of landfilling. Two, in particular, were the directions followed. First, the definition of quantitative targets for the reduction of waste placed in landfills. Second, the identification of strict criteria for consenting to landfill and the establishment of specific procedures for determining the suitability for landfill. The costs of these procedures of evaluation in most cases are borne by waste producers. I stop here and thank you for your attention.
So finally, we have one last question to Dr. Ricci. In particular, they want to know something about circular economy policies issued by European Commission. Dr. Ricci, please.
Yes, thank you for the question. And let me say, first of all, that with the notion of circular economy, we refer to a production and consumption model aimed at reducing natural resource waste. The circular economy, in particular, is based on a series of initiatives, among which those of the existing materials and products, sharing, reusing, repairing, and recycling for as long as possible. The main objective of circular economy is that of the waste amount reduction, which is pursued in a variety of ways. For example, we can think to the prevention during good design and goods production, or to the selection of processing waste that can be qualified as byproducts, or finally to the spread of recycling and of recovery processes. We must say that circular economy contributes to the climate neutrality and to the dissociation of economic growth from resources exploitation. And as specific regard to the question, public powers have a central role in inducing linear economy overcoming, and the European Commission in particular wants to establish a wide range of sustainability principles, and we can classify these principles and these initiatives into four categories. We can refer in particular to the communication of the Commission number 98 of 2020, with which were set a numbers of initiatives. And we can classify, as I said, these initiatives in four categories. First, we have that of environmentally friendly products from the design phase, and the main initiatives in this sense are that of the introduction of a product as service model. So manufacturers must retain product ownership or product performance responsibility throughout the product life cycle. Or we can think about the provision of criteria for environmentally friendly products identifications, giving the priority to products group belonging to certain value chains, for example, electronics. And finally, we can think to the provision of a review of the Eco-Design Directive for energy-related products. This is actually the directive number 125 of 2009, implemented by in Italy by legislative decree number 102 of 2014. Second, the Commission wants to enabling consumers and public purchasers to make informed choice. For example, through a review of EU legislation oriented towards a number of objectives. We can think, for example, of an EU eco-label brand update by integrating a series of methods such as, for example, that of information received at the point of sale about product lifetime and about repair services. Or we can think to the inclusion of durability, recyclability, and recycled content indication among the EU eco-label achievement criteria. Uh, the third group of initiatives adopted by the European Commission um, uh, is the strengthening the circularity of production processes. And for example, the Commission wants to amend the Industrial Emissions Directive, or it wants to promote the sustainable and circular bioeconomy sector. Finally, The fourth group of initiatives are about the creation of an efficient EU secondary raw material market. And for example, EU Commission wants to establish a secondary material market observatory, or wants to introduce a waste export regulation and some restrictions on the use of very high concern substances in products. So the time available to me does not me allow to further explore the topic, but I hope I have drawn a sufficiently clear framework about this. Thank you.
So thank you very much, Dr. Ricci, for this very interesting presentation. I would give you just some minutes for eventual questions, and then we can move on to the next presentation.